Good evening, everyone. My name is Linda Davenport, and I'm the Vice President and Senior Trust Officer at BECU Trust Services. And I'm here this evening with my colleague, Rochelle Chaplinsky, and she is one of our Senior Trust Officers as well. Just want to welcome you to Estate Planning, what everyone needs to know. If you're looking for a different session or topic, you can use the track buttons below to navigate throughout the event. We will be sure to include some time for Q&A at the end. You can click the question tab below the video player to submit your questions. You can also use the chat on the right side of the page to engage with the session. And I just wanted to go over kind of our agenda, the things that we'll be talking about. What is an estate plan is a topic that we'll cover. Who needs an estate plan? Planning for incapacity, wills and probate, and then trust basics. One thing before I get Rochelle kind of started on this, I think the most important thing to walk away with is probably asking yourself more questions about estate plan in your own personal situation. That is the goal. There is a lot to cover with estate planning, so we won't get through everything and be able to answer every question. But like I said, I think most important it is asking yourself questions. You know, do you have your estate plan prepared and that sort of thing. So with that, I will roll it over to Rochelle. And Rochelle, do you want to go ahead and talk about what an estate plan is?
I definitely can do so. Let me get over to that slide. So we're going to jump right on of defining what is an estate plan. I like to think about it as a map that reflects the way you want your personal affairs to be managed or handled in case of incapacity or death. Most people think when it comes to estate planning that it's just for individuals who have high net worth or who are wealthy. I hate to break it to you all, but that is not true. In fact, there's multiple people out there who need to put a plan in place. Oftentimes, if you don't put a plan in place, you lose control of what happens to your property or your assets should you become incapacitated or you pass away. If you have minor children, like I do, you don't have that control of saying who is going to be responsible for taking care of them if something happens to you. Who is going to be that person that you want to make decisions on their behalf? On this slide, you'll see a few scenarios, and this is just a handful of different situations of families, blended families, where planning is very important. There are individuals out there who may not have anybody. There's no safety net. Maybe their relatives or loved ones that they are planning on turning to don't live nearby, or they're in a different state. One common thing that I hear a lot from people that I talk to is, oh, I have somebody in place, but oftentimes that's a sibling who's older than them or a friend that's older than them. So that safety net is not always there. It's very important to have a plan if you have a spouse, a partner, or a loved one who is not financially experienced. Maybe you plan on leaving them an inheritance and they will not know how to manage it or what to do with it. But one of the biggest areas that planning is very crucial and very helpful with is preserving family harmony. You could have the best families while you're sitting around that dinner table, but I will tell you, the minute something happens, that's when the true colors come out. So right now, when you're thinking about estate planning, this is a time where you have control and you get to put the plan and the rules in place. When people think about estate planning or I talk to individuals, they automatically go to the very end. What is going to happen when I pass away? Who is going to get the china set or my car or my bank account? They oftentimes forget to talk about what's going to happen if I become incapacitated. In a situation where I cannot make decisions for myself, who is going to step in and make those decisions for me? There are three common documents that we see prepared for planning in this situation. The first is a durable financial power of attorney. This is a document where you get to pick who is going to step into your shoes when and if you need them to make financial decisions on your behalf. Like the durable financial power of attorney, there's one for healthcare as well. Again, similar, who is going to make those decisions when you can't make those healthcare decisions on your own? Who is the doctor going to come out to when you're in having surgery and they discovered that they have to take a right turn? Who is going to be authorized to give them that permission to take that right turn and do another procedure that may very well save your life? And then there's the directive to physicians. Oftentimes you'll hear that called a living will. This is where you get to put your end of life instructions in place. Do you want hydration? Do you want nutrition? Do you want pain management? You can take that burden of making that decision off your family by preparing this document. And your family is not always going to agree. There could be one family member who wants to go this way and another family member who wants to go the other way. Preserve that family harmony. This is the way that planning ahead will make you be able to make sure that your wishes are clear, they're in place, and it's your opportunity to make sure things go smoothly for your family.
And I think, Rochelle, one thing, you mentioned about, people have different ideas, right? I think most family members, right, they're going to have really good intention. Everybody wants the best for their loved one. The issue is when we have people that have different ideas of what that looks like, right? And that's where the friction starts. So, we find in administering these estates that families, everybody wants good intention, they have good intention, they want the best for their loved one, or they want, if somebody passes away, they want to do the right thing, but you just have individuals that have different ideas of what that looks like.
Absolutely. And one thing that I do want to point out, it's not specific to individuals who are aging that need power of attorneys in place.
Hmm.
Incapacity can strike at any times. Um, you may have college children who are off at school in a different state. And if something happens and you're trying to get access to medical information on their behalf, having that power of attorney in hand is going to save you a lot of time and a lot of back and forth in trying to get access to find out how your child may be doing medically in another state. If you don't plan, trust me, there is a default plan that's put in place, and that is a guardianship. This is a court appointed position where the courts will come in and designate a guardian to make both healthcare and financial decisions on your behalf. It's not always somebody that you know. It could be an individual, it could be a company. They can be costly as well. There is annual accountings that need to be filed with the courts that guardians have to prepare. Plus, the guardians themselves may be charging a fee for the work that they're doing. Timeliness is a big piece because you are subject to the court schedule in getting somebody appointed. It could take 4, sometimes 8 weeks to get this guardianship approved through the courts. And those 4 to 8 weeks can be crucial times, especially when there's urgent decisions and urgent needs that need to be made on your behalf. And then your wishes, your desires may not necessarily be played out because this could be a complete stranger stepping in to either make full life decisions on your behalf or even limited. But again, it's a default plan if you don't plan ahead and appoint somebody to step in on behalf of you in the event of incapacity. So, jumping then down the line from incapacity into the will, what is a will? It is the cornerstone of your estate plan. It's going to provide information on who you're designating to settle your estate when you pass away, who is going to receive your assets. Maybe you want a certain amount to go to certain individuals. Maybe you want money to go to charity. This is where you have control to be able to name and designate those individuals or those organizations that you desire. How does it go out? Do they get it immediately in a one time lump sum? Or do you spread it out over their lives to be able to make sure that they have something to carry them through some of the most important times of their lives? Maybe it's a young child who you know still needs to go through college, or even an older loved one who you know needs care down the road, especially going into retirement. And you can appoint when they receive those funds and how they receive it. You get to choose your executor. You get to choose a guardian for a minor child. That was probably the toughest one for me because, like a lot of parents, I don't feel like anybody's going to take care of my child the way I want them to, that I would take care of them. But at least I have a say in who I know is going to take the best care of them out of my choices that I have to choose from. And then you can create trusts and ways to provide for loved ones. And we'll get a little bit further into that later on in this presentation. But know that's more to come. And there's different ways that you can keep things ongoing and structured for somebody's lifetime.
So let's kind of talk about the executor itself, right? So this is, one of the things that in the business that we are in can see some challenges with. And selecting an executor is very important because, first of all, I think a lot of people don't realize that they have a legal responsibility to carry out their fiduciary duties, which is basically carrying out the wishes that are stated in the estate planning documents, the will, or it could even be a trust document. Um, Sometimes people that are in these roles don't really understand, like, let's just say, you decide to name a family member to take on the role as an executor. Sometimes they don't really understand their responsibilities, and because they don't do this day in and day out. So careful planning, or thinking about who the executor is to be for your estate plan is very, very important. They have to be loyal and impartial. For example, if I were an executor for my mom's will, and I have three siblings, I can't favor one sibling over another. You have to basically, file the probate, work with an attorney to open probate. You should post notice to creditors if there's any claims against the estate. You want to make sure that you do that, and that's a notice that the individual's passed away, so that allows creditors to step up to the plate and file a claim against the estate. If that's not done, um, it basically allows creditors in the future to come back to the estate or to the beneficiaries that inherited money. So a creditor's notice is very important. You have to collect and protect assets, right? So if you have a real estate asset, you have to make sure that it's insured. I could spend hours talking to you about all kinds of instances that we've experienced where this has gone sour. Um, Also assets. I mean, we know we're in a volatile market right now, right? So if there's an estate that has a lot of assets in the market and the market goes down and you didn't sell those assets in a timely manner, you could be held liable for that. So these are all things that an executor is responsible for doing that you, in planning your documents, need to think about. Tax liabilities, tax returns have to be filed. Final accountings for the estate have to be completed. Distribution of the assets have to be done. And of course, we all know when someone passes away, if there are beneficiaries, people are wanting their money immediately. So that management, and what Rochelle was talking about earlier with kind of, family dynamics, can really come into play here, because especially if you have a family member doing this job, it's a lot of pressure from other family members that are looking to get their assets sooner rather than later. But there is a process. And then eventually you have to close out the estate. You have to make sure that you've completed all of the above and then close out the estate. So it's a lot of work. The probate pros and cons, basically, I think, first of all, I think it's a myth that, probate is this big, scary, costly event here in Washington state. It's really not that complicated and it's not that costly. It is a process, so it can be time consuming. But the costs in general are pretty modest. The pros on probate too is that they are court supervised, so that is good. There is protection against creditors. On the con side, it can be time consuming with complex estates. But I honestly cannot say that I've not seen a complex estate, even though some people say, "Oh, my estate's very easy to administer." Yeah, there's a lot of family dynamics, which in oftentimes can make it more complex, right? There could be title transfer delays, things like that. Sometimes you can experience estate assets, say real estate, that might have an issue on the title report and you're trying to sell that. So there's all sorts of things that have to be addressed. Sometimes you might even have an estate where there's real estate outside of the state of Washington. That executor is then responsible for hiring an attorney in another state, to open probate in another state for that ancillary probate to settle the estate and that to deal with that asset in another state. The other con is that probate is public record, and sometimes people want to keep their information private, but that is something to think about. Can you avoid probate? You can, but I'm not sure that that's such a necessarily a good thing. Sometimes people try to do that, and things can get a little bit messy in their attempt to do that. But there are some ways you can avoid probate. You can own property jointly with rights of survivorship. So basically, that means that if you passed away, that anything in that account would go to the survivor or the joint person that owns that account with you. You can complete beneficiary designation forms or payable on death designation forms. So a really good example of that is like life insurance, right, or an IRA where you have a beneficiary designation form. A bank account. Sometimes people have payable on death or transfer on death or a beneficiary in their bank account. You can make lifetime gifts. There is a threshold that is about 130,000. If you're below that, you don't have to open up a probate. So your family member would not need to open probate. If you do own real estate, though, you have to open a probate, or the person that is your executor would have to do that. But you could make lifetime gifts and get assets out of your estate. We don't really see that very often. You can use trust to avoid probate as well. And all of the tools that I just mentioned, they they can help avoid probate, but they're not going to avoid estate tax. And we'll get into that in just a little bit.
One thing that I do want to point out that Linda mentioned was she talked about accounts with joints with rights of survivorship. We do see that a lot where somebody will go in and put a daughter or a son on their account for convenience purposes to pay, bills on behalf of them if need be or have access to the account. Be careful with that because that could throw off your whole entire estate plan, especially if they're joint with rights of survivorship. Because at your death, that account then goes to that joint account holder and may not necessarily flow to the beneficiaries that you designate that you want it to go to. In those situations where you do want to add somebody for convenience purposes, that's where using a power of attorney is very important.
Yeah, good points. Appreciate that, Rochelle.
Absolutely.
Yeah. So just, additional things to think about. The other thing that I want to mention too that we see often, which can be problematic, is that sometimes people will go to an attorney and they'll have an estate plan done. They'll have a will done. All of their assets will flow through their will, but then they turn around and then they have, different accounts. They have a bank account, checking, savings, CDs, maybe a money market, maybe an investment account somewhere, and then they start putting beneficiaries on all of those. And it really can kind of mess up the will over here that you drafted, that you paid probably a couple $1,000s with your attorney on. So be very careful when you're doing things like that. Think it through before, trying to, change accounts. Just make sure that it complements your will, or you're not messing up the intent of your will that you worked with an attorney on. Okay, so $1 million question we get often too is, should I have a trust or a will? We have presentations that we do, on our website from time to time on that. But basically, I'm just going to say in general, most people can suffice with a will. There are benefits of a revocable living trust. We'll get into that a little bit, but just in general, most people can get their needs taken care of through a will. So I will kind of leave it at that, and that can't take a deeper dive into that for this particular webinar. So what is a trust? It's basically an entity that holds property in which a trustor transfers property to a trustee for the benefit of a beneficiary. That's kind of a mouthful. But go to the next slide, Rochelle, and we'll talk about a couple of them here. So some of the primary ones that we have are a revocable living trust, which is what I just talked about. And these types of trusts are good for individuals that are concerned with incapacity. And also, like, if you're concerned with incapacity and you want someone to step into your shoes. The other thing is, if you have real estate outside of the state of Washington, instead of having probate in multiple states, you can create a revocable living trust and have the real estate, let's say in Arizona, that you might have titled in the name of the revocable living trust. If that's the case, a probate will not have to be opened in Arizona for that piece of real estate. So that is another feature of a revocable living trust. On the irrevocable trust side, irrevocable means just that. It can't be changed, right? So there's testamentary trusts, which are actually created within a will. So you can create a trust in the body and language of the document of your will. There's also a special needs trust that can be created, and that's an irrevocable trust, which is near and dear to my heart because I do have a daughter with special needs. And then there's also a credit shelter trust for tax planning. And again, we won't take deep dives into those types of trusts, but these are just kind of broad level, the different types of irrevocable trusts. Next slide, Rochelle. Thank you. So I touched earlier on will versus, kind of a trust. So, you know, what's the difference really, right, between the will versus a trust? So with a will, it's written and witnessed. It does not have to be notarized, but it does need to be witnessed to be legal in Washington state. A revocable living trust is just a written document. It's a written agreement contract. You can be the trustor, the trustee, and the beneficiary of your revocable living trust, which is what we often see at the onset when someone first drafts that. So with a will controls property after death, yes, you can control, the property that you have within a will, where you want it to go, when, and to whom, and you can even have those trusts drafted within a will. And also the same holds true with a revocable living trust. You can get very detailed in either document on, controlling property after death. And I kind of can think of that in my mind as controlling from the grave. But you can definitely do that. With a will, you can change your will or revoke it, and with a revocable living trust, that holds true as well. One thing I want to mention about the will is that oftentimes we do not see the personal property list along with the will. It's kind of there's a back page of a will that most people don't seem to fill out, but I will tell you that's probably by far one of the things family members disagree with the most, and that's that tangible personal property. Oftentimes, these are, have a lot of sentimental value rather than monetary value. So we would encourage everyone when you are getting your estate planning documents done that you also finish it out by, doing that personal property list. Who's going to get this special ring, or who's going to get your stamp collection, and things like that. So with a will, effective is after death. The will is not effective until that event takes place. And then with a revocable living trust, it's during your lifetime and after death. So it's for both. Within a will, you can list a guardian for a minor. In a revocable living trust, you do not. Getting back a little bit to a guardian, I want to touch on a couple of things. There are two different types of guardians. There's a guardian over the person and a guardian over the assets or over the estate. So just in the back of your mind, keep that terminology in the back, because as you kind of go through your own estate plan, those things will come up. So avoiding probate, a will, through a will, it does not avoid probate. With a revocable living trust, maybe. And the reason we say maybe is because oftentimes people, even though they have and create a revocable living trust, they don't put all of their assets titled in the name of the revocable living trust. So then anything outside of that revocable living trust, is more than likely going to be an asset that's part of your probate. And so, is it common that happens? It is, because not too many people are going to be titling their checking and savings account in the name of the revocable living trust. So if you're thinking about trying to avoid probate, it's very difficult to do, because again, oftentimes we always seem to find assets outside of the revocable living trust. So public record, yes, the will is after death. With a revocable living trust, it is more private, so no. Incapacity provisions, In a will, you don't really have incapacity provisions. Assets get distributed and that's kind of it. With a revocable living trust, you can put in a successor trustee who would basically step into your shoes if you become incapacitated. And that's one of the beauties of a revocable living trust and the benefits. So let's see, initial cost, you know, i- here we have will being less and a revocable living trust being more. I just say the more you talk, the more it's going to cost with the attorney. So get your information together. I mean, a will can, even in theory, cost more than a revocable living trust if you have lots of trust built into a will. So, it just depends on how much time and how much detail you get in either document is really going to dictate the cost. And then, so for upfront cost, there's none, or excuse me, upfront effort shows none with a will. And then, yes, because you're really not funding the will, action isn't really taken place until you pass away. With a revocable living trust, you do need to title assets into the name of the revocable living trust. And basically, that is funding the trust. And then with a will, there's really no asset management that goes along with that. I mean, you just have, your wishes listed in the document, who it's going to go to, whether it's going to go into trust or not. But with a revocable living trust, you actually have marketable securities potentially in that account, and those are being actively managed by yourself or by a professional.
So, what happens if you leave here today and you don't do a plan? You say, you know what, actually, I don't need one. There is a name for that. That's called intestacy or intestate. What happens to your assets if you do die intestate. Some property will pass automatically, like Linda had discussed on the prior slides. If you have joint owners with rights of survivorship, beneficiaries designated, you oftentimes see that on IRAs, life insurance policies, even on your bank accounts. You can add payable on death or transfer on death beneficiaries. But if you don't, you know, there is a plan in place, and Washington State and all the states across the nation do have plans in place. I did put what the actual RCW is here for Washington State. But what happens is they do look. They look to see if you're married. They look and see if you have children, if you have parents, if you have siblings, and they go far out. They even go out to cousins. So a lot of times when individuals say, "Oh, I'm worried that everything is going to go to the state if I pass away," um,
Mm.
trust me, there is a lot of time and effort spent on trying to find that distant cousin that you may have not even met to leave your assets to before the state will take it. But again, if you would rather see things go to a charity rather than a relative that you may not have ever met, making a plan, putting it in place will ensure that again your wishes get carried out the way that you plan for them to. So, in conclusion, I know that we covered a lot of information, and Linda and I can definitely talk on this topic for hours and hours and really get into the granular and drill in. But what we're hoping we accomplished is to get you thinking and, get those questions going, and thoughts of, what type of plan do I need? Have you implemented a plan for incapacity? Do you have that safety net in place if something happens to you and you're not able to make decisions on your own? And do you have a person in place that you're going to trust to make decisions on your behalf? If you do have a will, is it a valid will? Maybe you do have one and circumstances or things have happened in your life and you need to go make changes. That is very common. I always say, with cars, we take them in for their checkups every so often. Pull your will out, blow the dust off of it, read it, and make sure that nothing needs to be changed. And if something does, make the changes while you can. If
Yeah,
it's
Rochelle, one thing too, if I may, the other thing that I think about is that a lot of times we list people in our documents to take on these roles, right?
Mhm.
And like, an executor, I want my son or daughter or whomever to be the executor. You need to ask them, I think, if they want to take on that role. I think so often people just name individuals and individual family members, making the assumption that they're able to carry it out and carry out your wishes, and they may not want to do that. They may not be comfortable doing it. And so I think it's a really important dialogue to have with whomever you're thinking about appointing. And also just the fact that they have legal liability. And if they breach their fiduciary duty, they could get sued. So these are important discussions that everyone should have with whomever they're thinking that they would like to take on these roles.
Absolutely. So again, I think what Linda and I are both relaying is, if right now you have the power to make your plan, whether or not any of these questions, the things we talked about, drill in and make sure that there's no documents out there that you need to have drafted or done, or put into place just to make sure that everything goes smoothly for your loved ones. Um, Here are our disclosures. We are not attorneys. We are not CPAs. So we are not, this is for informational purposes only. Definitely for the legal and tax advice, we do recommend that you consult an attorney or an accountant. But if you do need to drill in and have more questions, just to get these concepts in place before you go in, we're definitely here to continue with the education piece of it. And then our contact information is below. So I believe we may have some questions. I think we're coming up at the end of our presentation. Oh, and there's TJ.
Hello, hello, but beautiful presentation, by the way. We do
Thank
have
you.
a question. What do you recommend on doing if they have assets, properties, pensions, retirement accounts across multiple different states? Is hiring a trust officer or lawyer for each state really necessary? Is there a way to simplify the options to pursue?
Yeah, I think that, what I was alluding to earlier with, a revocable living trust and definitely connecting with an attorney to talk about how to pull everything together is important. We are, as a trust company, we are available, definitely, to meet with folks and answer questions and maybe talk about what some of the options are in more detail, but definitely something that needs to be considered. But just kind of at first glance with the question, it would be a revocable living trust that I would definitely consider thinking about for that particular individual that asked the question, for sure.
Especially if there's real estate too, right?
Hmm.
We do see a lot of people who have a home here in Washington and maybe a vacation home in Arizona. Um, Even the laws when it comes to probate differ with states, and it could be so dramatically different that in those situations, that's where an attorney often will need to be hired in other states, to make sure that you're adhering to those state laws.
For sure.
Perfect. Thank you. And there is another question. If I do nothing now, would the spouse automatically become a power of attorney?
Linda, I'll let you take this one because you've had that situation.
Yeah, so not necessarily. I mean, you could, generally speaking, I think that yes, I mean, they could step in, but I mean, there could be a blended family where you might have an adult child that, wants to step in and kind of take on that role. So it's tricky. I personally had a situation where after my husband and I got married, I kind of thought, okay, everything's good, right? I'm going to be able to do things for him and he's going to be able to do things for me because we're married. And actually what happened is my husband was diagnosed with cancer a couple weeks after we got married, and I was wanting to kind of look through his medical records because, we were in the hospital and they had a 3-ring binder. I started looking through things, and doctors came into the room, took the binder away from me, and basically said, "You have no right to look at that information." And the reason is because I didn't have a power of attorney over healthcare appointing me, and my husband wasn't able to sign any consent. So it was a little bit shocking to me because I thought, hey, as a spouse, I should have the right, but that is not the case. So it is important to get the documents done. It's just going to avoid, any sort of issues. But I suppose there would be a default if something couldn't get done. There could be a guardian. And again, I think most important is if there's some family friction, then yeah, it's going to get more difficult to do. If it's just you as a spouse, probably not. But if you've got multiple family members, it could get more difficult.
Well, and then there's the HIPAA, the privacy laws that are out there.
Hmm.
ran into the same situation with my dad was out of the country when my mom had a procedure, so she wrote me on as the person to contact. And then you fast forward that, 2 years later, I'm at work and she's having another procedure and my dad's sitting at the hospital. They wouldn't give information to my dad because he wasn't the name in the file. So he
Yeah.
had to call me at work for them to relay how my mom's surgery went so that I could relay it to him.
Perfect. And there is another question in the chat as well. How much can it cost to get a simple will or power of attorney? Do attorneys always charge by the hour or flat fees? Can I do it without an attorney?
You want to take that one,
Yeah,
Rochelle? Yeah.
absolutely. So both, attorneys do charge, there are attorneys that will charge by the hour. There are attorneys out there that will do a flat fee. That's a question that I always encourage people to ask up front when they call the different offices to ask them what their fee schedules are to get an idea. I've seen the will power of attorney package cost anywhere from $1,000 for all three documents upward to you know well over $2,000 especially if there's multiple trusts in there. There are do-it-yourself documents out there like Quicken Wall Maker, and BECU even has a discount for members with Quicken Will Maker to be able to go and just create a simple will and power of attorneys yourself. So yeah, there are places that you can go where you don't necessarily have to have an attorney draft the documents for
Yeah,
you.
and some of the attorneys that we work with charge anywhere from about $800 to $1,200 for kind of just a basic will and the power of attorney documents as a flat fee. So that's just kind of a rough figure there.
Perfect. Thank you very much. That looks like that's all of our questions for the day. Thank you both very much for your presentation.
Okay, well, I'm just going to kind of close it out by saying we may not have been able to answer all the questions, right? Or maybe others are kind of stimulating some questions in your mind right now. If you have a question you'd like us to answer, please send it to communityrelations@becu.org. That is communityrelations@becu.org. There is a survey below. You can find it by scrolling down the page. Please take a moment to give us your feedback on this session. We like to know what went well, what didn't go well, so we can improve. And yeah, and then I guess we have this kind of concludes all the breakout sessions. But there is a keynote panel speaker or a keynote panel coming up, and that's starting in 5 minutes. We would love for you to join. And so we hope that you enjoyed our presentation. And thank you so much for taking your time out with us and spending it with us. And take care, everyone.